The first matter before the court this morning is Stephen Krznaric versus Sumo Rehab Hospital et al. Both sides will have 15 minutes to present oral argument. I know that the appellees already have the understanding that they can split their 15 minutes of time as you see fit. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time for rebuttal, please let me know when you get started. I'm keeping track of the clock, and you can also reference it on the wall over there. The arguments are being recorded, so please keep your voice up, remain at the podium. Please don't use the names of any victims or minors. As I indicated, we are recording this, and it will be posted on the court's YouTube channel. The judges have read your briefs. We are ready to proceed when you are.
Thank you, Your Honor. As a point of clarification, does that apply to the decedent, Ms. Krznaric? Do you not want me to say her name?
It doesn't. It really does not apply to the decedent in this case. Who is? Yes. Would you like to reserve any time for rebuttal?
Yes, please. 5 minutes.
Thank you.
Thank you. Good morning, Your Honors. My name is Blake Dixon. I represent Stephen Krznaric, who is the personal representative and the son of decedent Francis Krznaric. In this case, Ms. Krznaric was a patient of Sumo Rehab Hospital. It was determined that she was an extremely high fall risk, so she had been assigned a sitter who was supposed to be with her at all times. She was hallucinating. She did not speak English. She was legally blind. She was having all kinds of issues with her medication being adjusted, and she was never supposed to be left alone. On September 17th, 2018, the folks at Sumo Rehab sent her to an appointment with her neurologist, Dr. Donich, in a transport van, AMR transport with a transport driver. She was dropped off unattended at the facility, and after her appointment with Dr. Donich, she was left in the lobby unattended, where she stood up at one point, was told to sit down, stood up again, fell, cracked her head open on the floor, suffered a subdural hematoma, which caused her death about a month later. All three of the so there are three groups of defendants, two groups that owned Sumo Rehab, and then one group that constitutes the Donich defendants, the neurology doctor's office defendants. They've all filed motions for summary judgment. They've all been granted. We're here appealing that. The standard is de novo, and so basically your job is to determine, is there any way, construing all the facts in my favor, that reasonable people could find that there is a case here. And I would argue to you that there are literally dozens of reasons why there is a valid case here that's not subject to summary judgment. Number one, on the dating question, Ms. Krznaric's appointment was canceled, and presumably canceled by Sumo Rehab. She was certainly not in a position to cancel her own appointment.
Presumably, we don't know who canceled it, I take it from what you say.
Well, so, who could have done it? She couldn't have done it. Her family wasn't notified.
We don't know. There's no evidence in the record that says the doctor's office did it, Sumo Rehab, the family. It's not clear in the record. Is that fair?
There's no affirmative evidence, Your Honor, but if we look at the case, she was not able to do it.
Well, we can assume she did not, based upon her circumstances. We don't know who did.
There's affirmative evidence that her family was not notified of the appointment, and there is evidence in Dr. Donich's records that someone from Sumo Rehab had called and canceled it at some point.
Let me take a step back to something you said earlier.
Sure.
She arrived unattended at the doctor's office. Is that clear in the record as to when the AMR person stopped being with her if the person was ever with?
100%, Your Honor. And one of the most important parts of this case is when she gets there, Jessica Haraz, who's a certified nurse practitioner with Dr. Donich's office, calls back to Sumo Rehab and talks to Amber Lally and says, we have Francis Krznaric here to be seen. Someone, I don't know who, called and canceled the appointment. She is confused and only has a transport driver with her. So he does drop her off, but we do know that he leaves her.
Do we know when during the appointment process he left?
Leaves her in the lobby, does not go back with her to the appointment, is not with her after she's checked in. Do you know why no family or nurse tech is present with her? This nurse did verbalize that the patient was transported from a feeding group. Jessica states, okay, we will see her today, but next time patients with a Foley who are confused need someone with them. This RN did verbalize understanding, will monitor. Dr. Donich's records say, patient came to appointment from Sumo Rehab without a sitter, without an aide, without a family member. She had a Foley and a chair alarm on her wheelchair. I spoke with a nurse at a facility about not sending patients out without accompaniment when they are demented and not neurologically intact. Per the nurse, the patient had a sitter in the rehab. After the appointment, the patient was wheeled into the lobby. When she stood, she fell onto her left head on the floor. A nurse practitioner stayed with her until EMS arrived. So we do know that the transport driver leaves her. There is some testimony that Tammy Kimmel, who's a nurse with Summa Rehab, spoke with him afterwards, and he said something about being out in the parking lot smoking a cigarette, but we do know he's not with her in Dr. Donich's office. That's the purpose of Jessica Haras's phone call, to say nobody's here with her. So, we have Summa Rehab sending her to a canceled appointment. Summa Rehab not sending anybody with her. Summa Rehab not having a policy at the time that people who need a 24-hour sitter don't leave the facility unattended. Summa Rehab not notifying her family.
Summa's position is that by having a wait and return policy with AMR, that person was supposed to stay with the patient in this particular case, I'll call it.
Well, Your Honor,
And that's found, and they tell us that's found in AMR's record that there was a wait and return policy.
so AMR has a 3-page transport form. On the 3rd page, in little tiny handwritten letters, we see wait and return. What we don't know is whether the AMR driver had all 3 of these pages, because certainly everything he needs to do his job is on page 1. What we don't know is if he ever read wait and return before he went there. And what we don't know is what he thought wait and return meant. We do have testimony from the staff at Summa Rehab that clearly he did not understand that he was supposed to stay with this patient because he didn't. So we know that there's wait and return written on this form. We don't know if that was communicated to the driver.
Did the testimony from Summa indicate that he was told to wait and return or given any direction regarding that?
In fact, the opposite. I asked Tammy Kimmel, who's the nurse at Summa Rehab, did you ever tell him he had to stay with the patient? Her answer was no. I gave him the form. So she and everybody else is relying on the 3 words handwritten on page 3 of this form, wait and return. We also know that Tammy Kimmel was disciplined for the way that she talked to the transport driver. On September 17th, 2018, Tammy was the primary sitter for Francis Krznaric. AMR showed up to transport the patient to an appointment. Tammy notified AMR driver that she had a Foley. Lack of handoff to AMR by Tammy about the patient's cognition. Lack of communication to the RN to notify of the appointment. So Tammy is disciplined for the way she does the handoff. We also have testimony that after this, they changed the policy and they now have a written policy that nobody goes to an appointment who needs a sitter without that person present. That written policy was not in place at the time. My expert's critical of them not having that policy. My expert's critical of not training their staff to specifically say, look, if you got somebody who needs...
Who was your expert in that regard, Ms. White?
Yes, Dr. White, in her list of criticisms, talks about not training the staff not to send someone who needs a 24-hour sitter. I mean, this lady just wasn't suitable for transport. You know, I fall, I break my leg, I'm at rehab. They got to send me to my doctor's office in a wheelchair. The guy comes and picks me up, he puts me in the back of the van, he takes me there. This lady is seeing bugs in her milk, she's having conversations with people that aren't there, she doesn't speak English, she's legally blind, and her medications need to be adjusted. She's not suitable for transport. She needs somebody with her. Summa doesn't call her family. They have a policy that they're supposed to call her family and confirm an appointment. Her son actually happens to be at Summa Rehab at the time. He shows up to see her, and because they haven't called him, she's not there. He actually overhears the call coming in from Dr. Donich's office that she's had a fall. Her daughter's a nurse. They don't call her. She could have gone with her. So we have all these breaches leading up to her getting to the facility. Now she's at the facility, and Jessica Raz calls back to Amber Lally and tells them that she's there unattended, and nobody does anything. And that call is why intervening cause has nothing to do with this case. The transport driver drops her off. He's not there. I would argue he wasn't given adequate instructions, as evidenced by the fact that Tammy Kimmel was disciplined for not giving him adequate instructions. I would argue that they weren't properly trained, but let's assume he's given all the instructions in the world. Everyone in this case now knows he's not there, and nobody does anything. Summa doesn't send her sitter over to be with her. They don't call her family. They don't ask Dr. Donich if they're going to make sure they're going to stay with her. Dr. Donich's office accepts her. They don't make sure that somebody's with her. She goes back and she sees Dr. Donich, her neurologist. He knows her condition. And then she's wheeled out to the lobby and she's left there.
The trial court found that your expert, Dr. Feldman, testified that there was not a duty of care for the Dr. Don's office to have someone there to sit with her. In essence, I read the trial court's decision.
So what Dr. Feldman said was, you know, I'm not going to say that as a matter of course, all neurologists' offices have to have a policy of being with all of their patients at all times. But he clearly says that this patient should not have been left unattended. Now look, Dr. Donich's office could have fulfilled their standard by a lot of ways. She shows up for a canceled appointment. Sorry, no appointment, take her back. She shows up unaccompanied. Sorry, can't see her unaccompanied. We're not set up to be with people. So I think that's Dr. Feldman's point, is that to the extent that they're not able to have someone with her, that's okay, but then they don't see her, they don't let her come unaccompanied. They
So
say,
you would say
"Listen,
the trial court erred to the extent they said it was Dr. Feldman's opinion that the standard of care was not breached in this case.
oh, the trial court erred, I think, 20 different ways by saying the standard of care didn't breach. I mean, you know, we've got two experts who wrote long, detailed opinions where they articulated dozens of breaches of the standard of care. Frankly, I'm troubled by any trial court who's going to grant summary judgment on the big argument the plaintiff can't possibly make a case when they've got two qualified experts articulating numerous breaches. So
And counsel, you are reaching into that 5 minutes. You may continue or reserve your seat.
I will reserve my last 5 and pick it up at that point. Thank you.
Thank you. You'll have about 4.5 minutes.
Okay.
May it please the court, your honors. Mike Redinger representing Summa Rehab Hospital, Summa Health, and Summa Health System. As you noted, Judge Hensel, I will be splitting my time with counsel for Donich's office and counsel for defendant Viber.
Thank you.
May it please the court, your honors. This is an easy case for plaintiff's counsel to stand up, tell a admittedly sad story, and say that this kind of negligence, this kind of injury couldn't have happened unless somebody was negligent. But the trial court in its order had a straightforward response to that. When it assigned fault to the medical transport driver for unforeseeably leaving when he'd received wait and return instructions from Summa Rehab Hospital. But the medical transport company was never named as a defendant in this case. So the trial court was left in the position of telling plaintiff's counsel, sorry, you've sued the wrong parties. But this court doesn't even need to go that far in terms of affirming summary judgment in favor of the suing defendants. And that's because the medical negligence claim and the breach arguments that plaintiff's counsel has raised here today were addressed by the trial court in a straightforward application of the Drescher burden-shifting elements for summary judgment. When it comes to the breach issues in this case, the Summa defendants provided evidence as to 2 different prongs of the breach issues that satisfied their initial burden of proof. And that was by showing, first of all, that the standard of care is satisfied by issuing a wait and return instruction, which is uniformly, by the experts who were admitted to this case and at least 8 different fact witnesses, calls for the medical transport driver to provide one-on-one care by staying by the patient, in this case Ms. Krznaric's side, during the entire appointment.
Counsel, in reading the briefs, it seems to me like the only one that really said one-on-one care was your expert, who was the, I can't think of his name right now, but the expert in regard to transporting, who is the EMS trainer and so forth, and vice president.
Correct, Your Honor. That would be Dr. Wildenheim, or Mr. Wildenheim in that case. But it's also worth noting here that he was the only expert to address standard of care and have his opinions admitted. You heard Mr. Dixon talk quite a bit about how he has experts who have testified as to a standard of care violation and standard of care breach. Neither of those experts were admitted by the trial court as qualified. The trial court actually looked at the qualifications and excluded both of their sets of opinions. And by the way, to the extent that Mr. Dixon has said that this is a case about de novo standard of review, The trial court's decision as to the admissibility of expert testimony is subject to an abuse of discretion review.
Counsel, could I go back to a question I was asking?
Of course.
In that regard, I guess my question is, multiple depositions were taken, and everyone kept on referring to wait and return as meaning to stay, to transport back.
My recollection, Your Honor, is that the record actually indicates that, at least in some of these depositions, that wait and return indicates that they were surprised that the driver would have left the emergency room, or left the waiting room in this case. In fact, that's what Dr. Donish's office directly said, is that they were surprised that in this case that the driver would have even left this, and that's because everyone in the record suggests that wait and return indicates that they will remain in the waiting room until the patient begins their appointment and until the patient concludes their appointment.
And that's what I was getting at. So the point is, I don't know necessarily what all the significance of this is yet. However, the point is, your expert said they were supposed to stay, the transport driver is supposed to stay one-on-one even during the examination. And the first time I read that, I was like, well, what about HIPAA? What about all kinds of things? I mean, you can't just have anybody just go into somebody in an examination room and learn all that they want to know, and you have privacy rights. How's that addressed by anybody in this case?
The best way I can think of responding to that, Judge Carr, is that I don't have Mr. Wildenheim's testimony in front of me today. Taking what you've represented as face value, the inconsistency between that and what the fact witnesses have said is immaterial to the breach question before us in this case, and that regardless of any concerns with HIPAA rights, privacy, and aspects of that, it would not have, and there is no allegation that would have changed the causation aspect of whether Ms. Krznaric would have fallen in this instance, which is what the negligence claim here is fundamentally
But
about.
the whole point would that also go into whether or not the driver was the intervening superseding clause.
Respectfully, Your Honor, I don't think so, and admittedly, this calls for some degree of factual speculation here. But to the extent that the concern and that the alleged breach of the standard of care is that she was left alone, whether he was in there with her during the appointment itself or not, she would have had a one-on-one person with her that would have affected her and, based on the allegations in this case, been someone who would have been able to either assist her or prevent her from standing up on her own because she would have been with a medical provider at
And
that.
was there testimony that a transport driver would have been in the position to monitor someone to make sure that they don't fall, to instruct somebody to sit back down, to put their hands on the person, to tell them physically, give them the hands-on manual indication that they were to sit back down?
I do not recall whether Mr. Wildenheim specifically spelled out the mechanics physically of how a wait and return medical transport driver would assist the patient, but that he does testify, is my recollection, that by doing so, the failure to have a medical transport driver there could have been the proximate cause, and that it would not have been the proximate cause or would have been causally significant had the transport driver been able to remain with her to prevent that accident. I do want to address as well, not only is there evidence in the record that this wait and return order was provided, there is not, and I want to point this out, Mr. Dixon said affirmatively that there is evidence that the instructions were not conveyed to the transport driver. That's simply not accurate. There are at least two different forms here, both of which are admissible evidence in the forms of business records that show the instruction having been conveyed to the AMR transport company. One of those is AMR's own documentation, which Mr. Dixon has no evidence refuting that that wait and return instruction was given. The other is actually the Summa Rehab patient care report, which confirms that the driver was given both that AMR documentation and verbal instruction to remain with the patient. These are admissible business records, and therefore Summa Rehab has showed with evidence that by placing Ms. Krznaric in the care of a professional ambulette driver with a wait and return order, it had every expectation that she would be constantly supervised by someone, meeting the duty to provide one-on-one supervision. Against this, plaintiff hasn't offered any evidence to meet his reciprocal burden of showing a genuine issue of material fact as to breach. Probably the most important way in which that has happened is the lack of any admissible expert evidence showing a breach of the standard of care. Now, Mr. Dixon in his briefs, and a little here today, has suggested that the trial court wrongly excluded the expert testimony of his own expert, Carol White, who addressed the wait and return instruction and her view that that was not sufficient to meet the standard of care. He has not articulated any reason as to why the trial court would have erred, let alone abused its discretion in excluding Nurse White's testimony. The only argument that's been raised in the briefs on this issue is that there was no Daubert motion pending, that there was no affirmative motion to exclude pending by which the court ruled on it, so that he was ambushed by having to address his qualifications arguments. But the burden of proof he owes under Rule 56E requires him to come forward with affirmative admissible evidence refuting the initial showing by Summa Rehab Hospital and the Summa defendants. That includes an analysis of admissibility under Rule 702, which the trial court has authority to raise de novo and consider. So this issue was properly before the trial court and was properly decided. Before I conclude and before I yield the time to my co-defendants, I do want to address plaintiff's speculation that Summa Rehab is responsible because had it called to confirm the appointment, it would have learned the appointment was canceled, Ms. Krznaric would never have gone, and therefore would never have fallen. First, there is no admissible evidence in the record supporting the existence of a duty to confirm the appointment or suggesting that it is part of the standard of care. The only expert in this case to mention a duty to confirm the appointment or tie that to an alleged standard of care violation was again Nurse White, whose opinions were properly excluded. But even if this court were to give plaintiff the benefit of the doubt in crafting such a duty, plaintiff could never establish that Summa Rehab Hospital's alleged breach of that duty was the cause of her accident because of the unforeseeable act of the transport driver abandoning her, acting as an intervening and superseding cause as to that particular breach. Because at that point that Ms. Krznaric was arrived at the waiting room, the call was placed. You heard Mr. Dixon talk a lot about the call from Dr. Donish's office to Summa Rehab saying, well, this appointment was canceled. At that point, they confirmed that they will go ahead and see her, go forward with it, and at that point, the absence of the transport driver, whether or not the appointment was originally scheduled or was originally canceled, becomes the superseding cause that cuts off any alleged breach by Summa Rehab as to that. So, with that reason, we believe that summary judgment was appropriately granted in favor of the Summa defendants, and I would like to yield the rest of my time to Dr. Donish's counsel.
Thank you, Councilman.
May it please the court, Jason Passman on behalf of Dane Donish, MD, and Donish Neurosurgery and Spine LLC, in an effort to be brief to allow my co-appellee to respond on behalf of Viber. I will be very brief. With respect to your concern, Judge Stevenson, you are absolutely correct. There is no evidence provided by expert testimony in this case that a neurosurgeon seeing patients on an outpatient basis requires to provide one-on-one
Dr.
care.
Feldman said, based upon, as I understood his testimony that was in the trial court's opinion, that normally that's kind of true, but once we saw this person might have been at risk, he compared to someone having a seizure or a stroke or something like that, that there became a duty to make sure this person who was there unattended would be safe until they were attended. So that could be a question of fact for the trial court based on Dr. Feldman's testimony.
Well, no, Your Honor, because in this particular instance, there was no duty at that point in time because the trial court also noted that there was no prior issues with respect to safety concerns, as indicated by Ms. Krznaric during the course of her appointment. The testimony of Dr. Feldman was that in those situations where a person has a seizure or where they have a stroke, immediate care is required. And that's exactly what happened in this case. There was
Why
no...
did immediate care needed Peter? She is a person that clearly could not be by herself at that point in time. Why shouldn't the office have made sure she did not stand up or fall or injure herself?
Because she was within eyesight, Your Honor. She was within eyesight of the receptionists who were not otherwise trained. And Dr. Donish made that clear, that they're not trained for that, they're not set up for that. There's no indication that a receptionist is required to sit one-on-one.
So that would be your view, the duty of care would at least to keep eyes on her to make sure she was safe at that point in time. By doing that, the office met the duty of care by at least watching her to see where she was.
If that is what was required, but Your Honor, at this point in time, there's been no evidence that the neurosurgeon seeing patients on an outpatient basis, per Dr. Feldman, required to provide one-on-one care absent those circumstances. And in those circumstances, which occurred today, Ms. Krznaric fell, and she was seen. With respect to your questions, Judge Carr, on the intervening and superseding, that is exactly what happened. Dr. Feldman testified to a reasonable degree of probability that had Ms. Krznaric, or the ambulance driver, not left, he would have been able to there to provide. For these reasons, Your Honor, appellees request that this court issue an order affirming the granting of summary judgment by the trial court. Thank you.
May it please the court. My name is Jason Ferrante, and I am here representing Vibra SRH Holdings, a member only of Summa Rehab with no employees, no control, no management, no direct contact with the Summa Rehab facility. I'm here to make a couple points of clarification in terms of what the dispositive motions were that were filed. One, there was a Vibra SRH Holding filed for corporate veil piercing and the lack of the ability to do it, as well as a renewed motion regarding the corporate veil that joined into the Summa arguments regarding no involvement in care, plaintiff's experts stating that the facility met the standard of care, and no expert criticisms against Vibra SRH. Included within that addressed the intervening superseding and the lack of nursing home claims and punitive damages, but most importantly and most directly for purposes of Vibra outside the corporate veil issue was the fact that there were no expert criticisms against anyone at Vibra. That's usually what happens when you don't have an employee or a management company to make that type of criticism. In fact, the experts admitted that they were unqualified to make any criticisms against any of the Vibra SRH holdings. From there, that flies directly in the face of Bruni versus Tatsumi, which would require an expert criticism against us as a party in the case, in spite of, again, the inability to attribute liability to Vibra SRH Holdings because of its holding company status and no control, no management. That was in written discovery responses. It didn't need to get to the discovery that did proceed just before the motion for summary judgment was granted. So for those reasons, we join in the arguments that the trial court's order granting summary judgment should be upheld, not just directly or indirectly to Vibra as the holding company, but directly pursuant to the lack of expert testimony.
Thank you, counsel.
Thank you, Your Honors. Let me be crystal clear. My experts have not been thrown out of this case at all. The trial court ruled was that, first of all, there was some statement about they weren't sure if Dr. White was a physician or a nurse doctor. Then there was a discussion about that you can't give proximate cause opinions. We don't dispute that. She's a nurse. Dr. Feldman gives the proximate cause opinions. And then the trial court ruled that both Nurse White and Dr. Feldman were precluded from offering an expert opinion as to the standard of care of medical transport drivers only. So the notion that there's no expert testimony before this case of numerous breaches of the standard of care is simply not accurate. With respect to Dr. Feldman's testimony, what he says very specifically is Dr. Donach's office was aware of the need for such supervision, as it was Dr. Donach's office that notified Summa Rehab that Ms. Krznaric had been transported without a plan for appropriate supervision. This is acknowledged in the phone call that occurred between Dr. Donach's office and Summa Rehab on September 17, 2018, detailed the deposition of Jessica Jerez and verified in the records of Summa regarding the fact that the patient was dropped off for an appointment without any plan for somebody to accompany her. The failure of Summa Rehab and Dr. Donach and the employees of Donach Neurosurgery and Spine to deliver constant supervision to this patient at that time represents a breach in the standard of care. So defendants want to jump up and down and say because Dr. Feldman didn't say in his deposition that all neurologists have to accompany all patients at all times, he's given some big concession. He hasn't. In this case, knowing this patient as they did, they had a duty to give her supervision and they breached it.
Taking to the weight and return question raised by Sue. What evidence in the record would you point to that indicates weight and return means something other than this person is supposed to attend and be with the person at all times?
Melissa Loftus was deposed on December 9th, 2020, and she was asked, what's your understanding of weight return? She
And
said,
she is, and Melissa, I'm sorry.
Melissa
She's an employee of
Loftus.
SUMA?
Correct.
Okay, thank you.
And so Melissa Loftus was asked, what's your understanding of weight and return? And she went on and on about weight and return means you never leave their side. And I agree with Judge Carr. I'm troubled by a male transport driver, and somehow, I've never heard of this in 30 years of doing medical claims, going into the exam room while she disrobes, listening to her private information, but that's the claim. And so then I said to her, well, weight and return would mean they would stay with them and never leave their side. And Melissa Loftus said, well, that was our understanding. And I said, did that understanding turn out to be incorrect? And she said yes. So,
How do we know this person just didn't make a mistake? What are you telling me, the AMR record, or anyone else is out there saying that's not what weight and return means? Weight and return means you drive them there, you drop them off, you do what you feel like, and you pick them up when they're done.
well, so when I asked Tammy Kimmel if she told the driver anything, she said no, she relied on the form. So now we're back to these three words, weight and return. What we don't have is any evidence of what the AMR driver understood to be weight and return. But here's what we know. We don't have to get to foreseeability. We don't have to get to intervening cause, because everybody in this case knows he left. So let's assume he was given explicit instructions.
Well, that's not foreseeability, that's duty.
Well,
The
but,
the duty question is, do you have a duty to have, when you have her go, to have her safe to be, if you're assuming, to have her safe? And if you contracted with somebody that's supposed to stay with her the whole time, haven't you met that duty?
well, so if the nursing home finds out that their resident has eloped and he's down the street in the neighbor's yard, do they just say, well, it's not in our facility, so if he gets hit by a truck, tough
No, but
noodles.
she wasn't found in the neighbor's yard, she did a doctor's office from that call, came in. She wasn't just somewhere completely unsafe.
And Your Honor, why is that relevant? Because she's at a doctor's office, so you'd expect that doctor
Well, that
to
goes to
keep her
Dr.
safe.
Donich in the duty of care there, and I don't dispute that.
And so it's either or at that point, right? SUMA Rehab can discharge their duty once she's at Dr. Stonich's office by saying, okay, you got her. Are you gonna make sure she's unattended? If you're never unattended, you're gonna take care of her and get her back to us? Sure. But Dr. Donich says, we don't do that. That's not our thing. So if you believe Dr. Donich that that's not their thing, then SUMA Rehab has a duty. The trial court found that SUMA Rehab had a duty of constant supervision, and our expert has said, that doesn't end at the door. That includes appointments, that includes visits. If you're gonna give her to your family, you gotta figure out how she's gonna be attended, because it's not safe.
And counsel, you utilized your time, can you wrap up real quick?
Absolutely. So, so the last thing is, they did have a policy of confirming with the family. So that is a stated policy that they did violate, and there is evidence of that. And thank you very much, I appreciate it.
Thank you all for your presentations today. Court will take the matter under advisement. We will issue a written decision, which will be announced to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Thank you, gentlemen.
Thank you, Your Honor.